ashes trail she tread, among the ruins tales she's read. The past is shadow in her head, truths and wisdom all but dead. Cracked earth beneath her feet whispers where the heart beats me. History wrapped in secrets sweet, nature's call, a harsh repeat. Wander around the ruins, fierce and free. Eyes will tell to what used to be, speaking truth in the debris of what we lost and failed to see. Stars above a shattered sky, casting light on days gone by. Knowledge shared without a sigh, answers found where questions lie. Lonely road she walks alone, echoes in the silent drone. Roots of trees through steel and stone, life persists where she's unknown. Wander on the ruins, fierce and free. Eyes will tell to what used to be, speaking truths in the debris of what we lost and failed to see. What we lost and failed to see. Whoa, ooh, whoa, ooh.
Okay, good afternoon, everyone. How's my sound? Check, check, mic check. Hopefully it's coming along well. I won't keep you all very long today. I see that there's a couple of people going live between the 1:30 and 2 o'clock hour, so I will keep this rather quick. But I have grid power right now, so I figured I would pop on real quick to get this presentation out. I think it'll be the last presentation that I have regarding the social media and some of the laws that regulate what we see, what we hear, what we do, so on and so forth. And it's going to correspond with what is the hot topic in the true crime trauma community, which is the lawsuit between 10 plaintiffs, two of which happen to be YouTubers, and 2 defendants, which one happens to be a YouTuber and the other one happens to be a TikTok. I'm just going to go over what the stated purpose of the lawsuit is, and I know you all have seen it from different angles and everything, but there are a few misconceptions going on. One being that the plaintiffs are individuals and they only have a specific part to the lawsuit. That's not the law. That's incorrect, and I'm going to show you that. And also, too, that the pattern of behaviors that could be considered defamatory or harassing, bullying, that type of language, they're trying to indicate through the filing that shows a pattern which would indicate an enterprise and or a predicate act. And I am going to show you in law and in court precedents with a civil racketeering case that's just factually incorrect. Okay. And I'm also going to touch on why this all matters. Taking the parties out of it, take the personalities out of it, take the channel creators out of it, take them out of it. But on the face of what they're trying to say, and I'll get into that as we get to that portion. And I apologize if you hear any traffic noises, but we do have almost a quarter-inch of ice out my way, and we have salt trucks and cinder trucks going through because we are having more. Hi, Cash. How Chow? Chow, it's so good to see you. My goodness gracious, it's been forever. Quick side note, I have a package for you. I've not been able to get to the post office between the amount of snow that's been on the ground and my incapacity due to illness, but it is going to go out, God willing, on Friday. So I didn't forget about you this year. Okay. Sorry, squirrel moment. And what else did I want to touch on? Oh, and I may also throw in a quick personal opinion because I saw something. Well, actually, a couple of things were brought to my attention. And I don't know if somebody thinks they're trying to stir the pot or to start crap between me and other creators, but that stops today. That's not going to happen. That's not how I play the game. Okay, that's not the type of person that I am. Now, I did have a knee-jerk reaction because how something was presented to me was quite different than when I went to go watch it for myself. Because I'll tell you, 3 days ago, I was ready to go scorched earth. And you know what? I've had my time. I've counted to 10. And taking everything into consideration, YouTube isn't my job. I wouldn't even class it as a hobby. I came back because I saw that there was a need for a different approach in education and opening the door because, again, misconceptions or misrepresentation of how certain things are done. After this presentation today, I think I'll be closing. Hi, Maccabees. It's so good to see you. Thank you for coming in. I really appreciate the work you've been doing, keeping things factual and calling out the bad actors in your community. I really appreciate it. And Paula, I appreciate the work you've been doing in the faith-based sector as well. And Chow, of course, absolutely always appreciate your time-lapse photography. And Cash, you keep everybody on their toes out here on these YouTube streets. So without further ado, I'm going to pop into the presentation. Double check y'all can hear me okay? Okay, yeah, it looks like that's good. All right. And so, as the thumbnail indicates, but we're investigating the case. That's what we hear in regards to this missing teenager out of Tennessee. And we have spokespeoples that have come in, a bounty hunter, canine handlers, fake canine handlers, restraining orders, lawsuits, and of all things, I guess nobody had this on their bingo card, a RICO, which is a racketeering charge against a YouTuber. So now that we see we're going to tell you a lawsuit. A lawsuit is a civil legal action by one person or an entity, the plaintiff, against another person or entity, the defendant, to be decided in court. Normal disclaimers. Nothing in this presentation is to be taken as legal advice. This presentation is simply a visual guide referring to civil litigation in the Commonwealth of Pennsylvania and the United States. Definitions, procedures, and resources. Do your own research, and as always, the laws in the United States are constantly changing and being updated. That goes for also the Commonwealth of PA. A plaintiff. A plaintiff is a person who brings an action, the party who complains or sues in a personal action and is so named on the record. Defendant. Defendant is the person defending or denying the party against whom relief or recovery is sought in the action or suit. In common usage, this term is applied to the party put upon his defense or summoned to answer a charge or complaint in any species of action, civil, criminal, or in equity. An exhibit. To show or display, to offer or present for inspection, to produce anything in public, so that it may be taken into possession, to present, to offer publicly or officially, to file for the record. A declaration. Now, I believe that the majority of people within this genre or this sector or on this side of the tracks of YouTube is aware of the suit. You can find it. It is available publicly, and you can access that through the Pennsylvania docket or through the Delaware County website for Pennsylvania. And if you have not seen them, you can, Granny's Watching has gone over them, and Nonsense on the Web is the YouTube channel. She has brought them up as well as several other YouTubers. You can do a YouTube search for, I guess you would probably just put in RICO, Granny's Watching, or YouTubers, RICO filing, something along those lines, and it'll come up. I'll provide additional links in the description later for channels that have also gone over the actual documents. I do have them. I have them in PDF file. So if there's time, I may go over them, but I want to try to get this done within the hour. A declaration in pleading, the first of the pleadings on the part of the plaintiff in an action at law, being a formal and methodical specification of the facts and circumstances constituting his cause of action. It commonly comprises several sections and divisions called counts, and its formal parts follow each other in this order: title, venue, commencement, cause of action, counts, conclusion. The declaration at common law answers to the libel in ecclesiastical and admiralty law, the bill in equity, the petition in civil law, the complaint in code pleading, and the count in row actions. And then you can read further or screen grab this slide if you wish. Okay. If you are a plaintiff in a lawsuit, you are the plaintiff to the entire complaint filed against the defendant, meaning you are the party initiating the whole legal action and making the claims outlined within the complaint document. Cash. Okay. All right. I think you do this. There you go. Okay. All right. Thank you. Thank you, guys. Thank you so much for being here. I really do appreciate it. I'm going to go over this one more time because not just one person, not just two people, not even just three people, but so far to my ears, I've heard 5 individuals indicate that the plaintiffs, of which there are 10, possibly 11, but 10 in the filing, that they each have their own section, that they have their own portion of the complaint, so they're not party to what others are doing or to whom the other defendants may be. So I'll read this again. If you are a plaintiff in a lawsuit, you are the plaintiff to the entire complaint filed against the defendant, meaning you are the party initiating the whole legal action and making all the claims outlined within the complaint document. And again, the source for this information will be Black's Law Dictionary, ISBN 979-835-02-90899, publisher Thompson West, copyright 2024. And I'm sure you'll be able to locate this if you just do a Google, as so many are fond of doing. And while I say that, I did see a comment in regards to a comment that I had made, that all these YouTube lawyers and everything, and where did so-and-so get their law degree? Duquesne University. Thank you. Next slide. An enterprise. An enterprise, a corporation, business, firm, company, or registered group with a designated purpose. More typically, a group driven by initiative and resourcefulness, incorporated or not, organized to conduct entrepreneurial activity. And this case in point is RICO, an act that was passed by Congress in 1970. It was established in order to increase the penalties for wrongful criminal acts relative to the mafia. I'm sure we all are familiar with what a RICO is. Now let's go into discovery. And there seems to be a little bit of a misconception about what actually discovery is. So I will go ahead and say that again. Discovery. If you're facing litigation, you may be wondering, what is discovery in law? The term discovery refers to the lengthy, often invasive, yes, often invasive, pre-trial investigation phase in which parties request evidence from each other and outside sources. Interrogatories are written questions for witnesses or litigants. Depositions are oral interviews with witnesses or litigants. Requests for admissions are written requests for a party to state something is true or false. Requests for production are written requests for a party to produce documents or things, and subpoenas are court orders from a judge to produce documents or things. And again, you can find this through Black's Law Dictionary, or again, you can do a Google search. Moving forward. Also, an injunction. An injunction, because the beginning of the filing, it was specified they want injunctive relief. And the injunctive relief is to not speak on a certain case, or to not to defame or make slanderous statements or provide misinformation. Some of that could be subjective, as opinion or hyperbole and statements in the heat of the moment, or just going over, which would be our free speech and our freedom of expression. Oh, excuse me a moment. I apologize. I'm recovering. An injunction in law, a judicial order that restrains a person from beginning or continuing an action threatening or invading the legal right of another, or that compels a person to carry out a certain act. Example given, to make restitution to an injured party. Injunction, junction. Again, Black's Law Dictionary. You may also find this in civil statutes of the United States, the RICO of the United States through the Justice Department, and the Pennsylvania General Assembly. One moment, please. Copy. There you go. I've just dropped the information for Pennsylvania, because this was filed in the state of Pennsylvania. And on a side note, I will bring up, why does this matter? And why am I even interested in this if I don't involve myself in drama or dramatic activities? I'm a resident of the Commonwealth of Pennsylvania. So what happens with this will have an impact on me as a citizen of Pennsylvania. Because should this novel approach to filing a RICO based on defamation, cyberbullying, trying to claim that because two creators communicate, held a panel together, and are collecting ad revenue from YouTube, collecting super chats from YouTube, receiving cash apps from YouTube, receiving any financial gain from their YouTube channel, the implication is that that would constitute an enterprise. And while they're on this channel collecting money and collaborating with one another, because they may be saying things that hurt people's feelings, or they may be saying things based on their opinion on how they perceive the information that they've been presented, that's an enterprise. And that's ill-gotten gains because, well, that's not how it is because so-and-so said so. I encourage people to read the 380 plus pages of that, and do so at your own peril, honestly. And I'm not trying to be flippant, and I'm not trying to, nor am I diminishing that somebody may have hurt feelings, but to equate, and here's the thing, this is a novel approach, because if this is allowed to proceed, that individuals that collaborate on YouTube, Facebook, Kick, social media, Rumble, wherever, and because they're receiving financial remuneration through having a monetized channel or donations, to say that that's somehow an enterprise, and that there's collaboration, not in the sense that, oh, I'm working with you as another creator, but collaboration as in conspiring to further a nefarious goal. Wow, that's interesting, and that's why I am very concerned about this. Okay, because that it would have ramifications that would trickle down. And cyberbullying. How does the law define cyberbullying? Intentionally places another person in reasonable fear for their safety or the safety of their family by means of electronic communication without their consent to cause the person unwanted physical contact, injury, or harassment. Now, with this, keep in mind that if you are going into somebody's chat and textually assaulting them, which would be the equivalent of verbally assaulting them or tearing them down or whatever, you're making the effort to go to them and to say this stuff. So the person that it's directed to, it's unwanted contact. They didn't ask you to come in and call them a piece of garbage. Okay. However, if I'm on my channel stating something and somebody doesn't agree with what I've had to say about somebody else, and then somebody in that chat goes to that person and says, listen, I heard Wendy said you're a piece of garbage and XYZ. I didn't go to that person and do that. I'm not harassing them. I'm not bullying them. I'm not seeking them out. My community is having a discussion. It's the other person that brought it to them. And if they choose to listen to it or come in, that's on them. There is something called personal responsibility for what you allow into your own ears. And say that again. There's something called personal responsibility personal accountability. Some people are abrasive. As Cash said, some creators can be considered condescending. It's a personality trait. That doesn't inherently mean that they're saying things just to say them to be mean to hurt somebody else's feelings. If they're saying it in general, they're not going after, they're not taking themselves to that person and telling them about themselves. If that, I hope that makes sense. But it's just, and cyberbullying, the concept and how that came about, that was for children. Because with the advent of social media, children were being harassed and bullied, and it was leaving the schoolyard, and they were getting no peace. And it's, I'll go on to the next slide. I'm going off on a tangent. This slide is not working. Okay, that's harassment. I think you all would know what harassment is. Okay, now, because there seems to be, again, a misunderstanding about more than one plaintiff or more than one defendant and how that works, there's something called a joinder. It is a process in which parties and claims are added to an ongoing lawsuit. The typical litigation scenario begins with the plaintiff who enters into a lawsuit by suing a defendant. The plaintiff has a claim against the defendant for which he or she seeks some type of relief. However, sometimes another party has a role in the lawsuit, or there may be additional legal claims which arose out of the same controversy. In these situations, joinder may be invoked to combine these parties and claims. As always, it is necessary to properly ascertain whether jurisdiction may be acquired over the parties and claims before trying to join them in a lawsuit. And I think that some are right in saying that the reason that the two defendants, going by the nom de plumes or the screen names of BBQLady and Granny's Watching, was brought because they are in Pennsylvania, and the umbrella or the top of the iceberg that filed these claims was based in Pennsylvania. Okay, and in regards to joinder, there's rules, Rule 19 and 20 specifically. Rule 19 states that a party is necessary to a lawsuit when one of two conditions arise. The party must be present in order to award complete relief, or the party has an interest in the action so that his or her interest cannot be represented and protected without that party appearing in the lawsuit. And Rule 20, I think, is important, and I've highlighted it extra with the pretty colors, is permits the joinder of parties whom the claims arise out of the same events and they involve the same legal questions. Two or more plaintiffs may join together and sue a defendant. Alternatively, a plaintiff may sue two or more defendants. Joinder of parties under Rule 20 is not required and is often referred to as a permissive joinder. Initially, the decision belongs to the plaintiff as to whether to join two or more defendants in the lawsuit. So when you have 10 plaintiffs, one would assume that they've had discussion among themselves with their legal counsel. And as a group, as a collective, they made a decision that these are the individuals that we want to sue. These two are the individuals that we want relief. We want the court to give us relief from their actions. One would assume that. That's normally how things are done. Was this done in this case? I don't know. I'm going to assume that it was. And there's just been perhaps a bit of miscommunication or misunderstanding on how things work. And as some of you know, a private investigator has become an intervener. How is that possible? How is somebody that's not a party to the lawsuit coming in and filing paperwork and interjecting themselves into this complaint? Well, it is possible, and it's called an intervention, and it's Rule 24 of the Civil Proceedings. Rule 24 controls intervention or the introduction of a non-party who has an interest in the lawsuit. The non-party wishes to protect its rights by presenting a claim or defense or both. There are two types of intervention. First, there's an intervention as of right, where the party intervening, known as the intervener, has an interest in property or a transaction which is subject to a lawsuit. And then you can screenshot this and read further. And I also over here, the alternative form, there we go, of intervention, permissive intervention, allows for intervention where the intervener's claim or defense has a common question of law or fact with the ongoing lawsuit. Permissive intervention is subject to the decision of the sitting court. The court may decide to allow or disallow that intervention in the case. Now, I have provided a case for y'all from 2002. It's Hussein versus Boston Old Colony Insurance Company from the Fifth Circuit. Important note, while much of this may refer to personal injury, property damage, or bad faith, these cases will provide a foundation for understanding the outlined concepts that I'm presenting here for you. Okay, now, here we're going to get into some meat and potatoes. Predicate acts and civil racketeering claims. To start, it is important to understand what a RICO violation entails. While racketeering is colloquially defined as fraudulent and otherwise dishonest business dealings, the legal definition is more technical. A predicate act is simply one of the criminal offenses listed in the statute itself. Predicate acts in a civil racketeering claim include the following: wire fraud, mail fraud, embezzlement of funds, attempts to extort money, and bribery. In other words, a predicate act is simply an independent, illegal form of racketeering activity. As a foundation of any civil RICO lawsuit, whether filed under federal law or Pennsylvania state law, a plaintiff must prove that the defendant or defendants engaged in racketeering activity. This requires presenting evidence that there was some type of predicate act by the defendant. It could be mail fraud, wire fraud, an extortion attempt, or any combination of racketeering activities. Beyond the foundation, pattern, enterprise, and damages. And that's one thing we've been hearing from several individuals, is that, well, we're just showing a pattern of activity. See, this is the pattern. This is her pattern. This is their pattern. Establishing liability in a civil racketeering case requires plaintiffs to clear a relatively high bar. It is not sufficient to prove that the defendant engaged in a predicate act such as mail fraud, wire fraud, or an extortion attempt. That is merely one key step in building the foundation of a successful civil RICO lawsuit. There are three other key things that plaintiffs must prove to prevail in civil racketeering litigation. Pattern. A one-time predicate act is not sufficient to impose civil RICO liability. The statute requires a pattern of racketeering activity. By law, a pattern requires a minimum of two predicate acts that are closely related. Enterprise. The pattern of predicate acts must have occurred as part of an enterprise. The enterprise can either be a formal organization or an informal organization. Damages. As with other types of civil legal claims, the plaintiff must have sustained actual damages to impose liability and recover compensatory damages. A plaintiff must prove that their damages were caused by the defendant's racketeering activity. Sources: Civil Statute, U.S. Code, RICO of the United States through the Justice Department, and the Pennsylvania General Assembly. Predicate acts and civil racketeering continued. Walker versus Beaumont, Indiana School District, 5th Circuit, 2019. The 5th Circuit Court of Appeals held that neither defamation, intentional interference, nor online harassment can be considered predicate acts under the Racketeering, Influence, and Corrupt Organization Act, RICO, meaning they cannot be used as a basis for a RICO claim. This is because Section 1961(1) of the RICO statute only lists specific criminal acts that qualify as predicate acts, and these torts are not included in that list. Note of importance. Important but not related to the current injunction RICO being discussed in regards to YouTubers BBQ and Granny's Watching. Congress amended the RICO Act in 1995. Civil RICO claims cannot be predicated on securities fraud violations unless the defendant has been criminally convicted of a securities fraud violation. The 18 U.S. Statute Code 1964 CC Swartz versus KPMG LLP and 9th Circuit 2007. The plaintiff's civil RICO claims were barred where the defendant had not been convicted of securities fraud and where the sale of stock was the linchpin of defendant's alleged fraudulent scheme, Bixler versus Mineral Energy and Technology Corp. You can screenshot that and look that up also at your leisure. Okay. Note of importance. Is there a chance that filing a complaint could get me in trouble? Yes. When you sign a complaint or any other court document, you are certifying to the court that you have conducted an inquiry into the facts and the law, and that you are filing the complaint for any you are not filing the complaint for any improper purposes, such as to harass the other side, cause unnecessary delay, or needlessly increase the cost of litigation. Your claims and legal contentions in the complaint have a basis in existing law, or you have a good faith argument that existing law should be extended or changed. And I think this is what's important about this, the claims made in the civil RICO complaint as it pertains to the utilization of a YouTube channel and the collecting of funds as far as super chats or monetization. When you start breaking it down, and there's nuance there, and that's what has me concerned. Okay, continuing. You have evidence to support the allegations and facts in the complaint, unless you specifically allege a fact based only on your information and belief. If you file a complaint without any legal or factual support, or for some improper purpose, the court can sanction you. That means the court could require you to pay money to the other side or to the court. It could also dismiss your case or fashion some other sanction sufficient to deter you from repeating your conduct. In some situations, the defendant you name in your complaint could actually sue you for abusing the legal process and harming them. Here are some additional resources and materials. Anonymous blogging, a technical guide to anonymous blogging, CyberSlap, which was founded to oppose the practice of filing a meritless lawsuit in order to use subpoenas to pierce a critic's anonymity. I need a drink. Okay, one moment. I need some water. Okay. A podcasting legal guide. Welcome to Podcasting, a legal guide for podcasters, Chilling Effects Clearinghouse, Media Law Resource Center, Stanford's University Fair Use Site, Pennsylvania General Assembly, Statutes for Pennsylvania, Consolidated Statute, Corrupt Organizations, Cornell University, Law Library and Research, Public Access. An excellent book I recommend is by Jeffrey E. Grill on RICO. You can find that online at ricoact.com. Please refer back to my previous presentations for individual slides, resources pertaining to defamation, slander, libel, free speech, and limitations thereof, the presumption of innocence, conjecture, hearsay, and speculation. Each presentation provides source links and materials for further review if you would like them. Whew, okay, I thank you guys for being here. I just wanted to clear up some of the misconceptions. What kind of brought me to this is because a couple of comments I've made in some chats have been reviewed and brought up, and I just wanted to, as they say, give my side and to provide some clarity where there may be some misconception or ambiguity. I appreciate y'all being here. And there you go. And on that note, I am going to take you out with a song.
Bullhorn Betty, Bullhorn Betty got herself in a jam. Oh, Bullhorn Betty, fixing to get put up in slam. Oh, Bullhorn Betty, a fake press pass, judge gonna take her down fast. Got herself in a jam. Tennessee judge backing her off to slam. Oh, Bullhorn Betty. Oh, Bullhorn Betty. Tennessee judge backing her off to slam. Oh.